Right. Welcome everyone to this webinar on renters' rights and the state of the eviction moratorium. My name is Megan Gibson. I'm a housing and economic development analyst with the city of Evanston. Tonight, I am joined by our presenters, Michelle Gilbert from Lawyers Committee for Better Housing and Javier Ruiz from Metropolitan Tenants Organization. A quick few housekeeping details before we get started. This webinar does contain general legal information. Renters should make sure to talk to an attorney for specific legal advice. LCBH does represent renters in eviction court, but tonight we're not going to be answering specific personal legal questions as it is a public forum. And yeah, just a quick note, this area of law is changing constantly and maybe different by the time you will get to eviction court. You could get to eviction court, which is always true, but especially now. The chat function is going to be off for this evening, but if you have a question, please feel free to submit it through the Q&A function, and we'll have some time toward the end of the presentation to go through your questions. So with that, I'm going to hand this over to Michelle and Javier.
Thank you, Megan and City of Evanston. I know that this is a really pressing issue on people's minds. So hopefully we'll give you some information that will help relieve some of the stress. And definitely we've saved a lot of time for questions. Megan has gone through the ground rules. Again, we try to keep abreast of the law, but nothing has changed as much as eviction law during COVID. And again, with the personal legal questions, I have information at the end of the eviction portion of the program. If you need to talk to an attorney right now, I can explain how you can do that. So the first most important thing, if you are worried that you are at risk of eviction because you have been unable to pay your rent because of COVID, the most important thing that you can be doing right now is connecting with a rental assistance provider. And if you have not applied for any assistance now, the way to go is with the Illinois Department of Human Services. You may have heard about the Illinois Housing Development Authority. For right now, that portal to that rental assistance is closed as they process the applications that were made in May through July. But the Department of Human Services does have rental assistance available. And if you go to this website, and we will be making the slides available after the presentation. If you go to this website, it will help you find a provider. I looked at the list, and it seems like the logical provider for people in Evanston would be Connections for the Homeless, and their phone number is right there. So before we talk about evictions during COVID, it's helpful to talk a little bit about evictions normally. And eviction is really a 5-step process. The landlord has to give some kind of termination notice. Then the landlord files a case in court. Once the filing takes place, the landlord gives the paperwork to a sheriff or to a special process server, and the tenant is served. Then there have to be court hearings. And finally, there's some sort of court order, and that is usually there's some sort of agreement. And if not an agreement, there is a trial. It can be a jury trial or a bench trial. And the third alternative is if the tenant doesn't go to court at all, the tenant can be found in default, and then a default order is entered. And that's usually not a good thing. And then finally, once there's an eviction order, the landlord goes back to the sheriff to enforce the eviction order. So all 5 of these steps have to be followed. And honestly, each of the 5 steps have been changed during the COVID period. So first I'm going to talk about generally about notice and then changes to the notice process. So there are basically three kinds of notice. One is if the tenant owes rent. The other is if there's some sort of breach of lease. And those are what we call for cause notices, meaning the landlord has some cause or reason to file the eviction. And then there are no cause cases, and it's just the end of the lease, or maybe you never had a written lease and it's just a month to month and the landlord has decided that they want to rent to somebody else. So a notice for non-compliance with the lease in Evanston has to be 30 days. For non-payment of rent has to be 10 days. And non-renewal of the tenancy, you know, those lease expiration notices, has to be 30 days. Evanston is the only place in the state of Illinois that has 10 days for non-payment. So you'll have to forgive me if at some point I slip up and call it a 5-day notice, because that's what it's called everywhere else. But during that 10 days, it is the tenant's right to be able to pay the rent that's due, and then the landlord can't go ahead with the case. Also, if there is an alleged lease violation, the tenant has a right to attempt to cure it. You know, what does that mean? Some things are kind of obvious, like if there's a dog or an unauthorized human, even that person or the dog is removed, then the tenant is no longer in violation of their lease, and so they have cured the violation. Okay. So you may have here at some point that there is a new Cook County residential tenant landlord ordinance. And one of the things that's really great about that is that there is a right to cure that is longer than just the 5-day or the 10-day period. It's up to the point in which the tenant is in court. So the Cook County ordinance does not apply in Chicago, in the city of Chicago, in Evanston, Mount Prospect, and Oak Park, because they have adopted comprehensive ordinances. You know, this is, you know, one area to look at in the Evanston ordinance, extending this pay to stay period. Okay. The next step, once the landlord has given a proper notice, is to file the case. And nothing prevents right now a landlord from filing an eviction case. So you may know that there has been an eviction moratorium in Illinois, and the Illinois eviction moratorium, unlike the CDC moratorium, which you've probably also heard about, has gotten a lot in the news lately. The Illinois moratorium has mostly prevented landlords from filing cases after they serve the notice, but that protection is no longer in place. Right now, nothing is stopping anyone from filing anything. And I don't have much in the way of court records, what's actually happening, but I can tell you in terms of calls to our office, really the number has tripled since in the last couple of weeks, now that landlords can file cases. If your landlord has applied to the Illinois Housing Development Authority for rental assistance, then in that application, they agreed not to file the case. But I gotta tell you, a lot of people are not following that. So that is, you know, they may end up filing the case, but it still should allow protection and should allow, if they have filed the case, to get it dismissed. Okay. You may also have heard that to trigger any protections in Illinois, the tenant needed to be a, quote, covered person. So this still applies. Watch this space. This likely will change in September. But for right now, the landlord has to give a blank declaration with any notice, and the tenant can return it. Even though it doesn't prevent the filing, it does provide some other rights. If your landlord doesn't give you a declaration, you don't have to wait for it. You can actually go to our website, rentervention.com, and prepare a declaration. And that's kind of a nice way to do it, because then you have an electronic copy of it. So declaration, boy, when I was doing this presentation earlier in the year, I would say the word declaration like hundreds of times a day. So even though it is being transitioned out, like I said, it's still relevant. A declaration that would make you a covered person. You swear under oath that you have an income below $99,000. That one's usually pretty easy. That you have COVID-related financial loss. It doesn't have to be that you lost your job. It could be that your hours were cut, or that you had increased expenses, and that you likely would become homeless. Yes, I skipped over number 3 because number 3 is the most complicated, that you've made attempts at partial payments if you can. Certainly, I think if you're still behind, if you're waiting for rental assistance, but you have some income now, please reach out to your landlord. If the landlord says, oh, I'm not taking it unless you give me all the money, then try to keep a record of that. But certainly if you're trying to reach out to the landlord to make a partial payment, try to do it in a way, texting, email if you can, that you could later prove that you were attempting to make partial payments. All right. So there are a whole bunch of rules about what landlords need to attach and what they need to certify. And there's going to be a landlord presentation on Wednesday, and those presenters are people who are representing landlords, and so they'll go in much more detail about what a landlord needs to attach. These rules aren't going to prevent the landlord from filing the case like the moratorium did, but it is going to make it a little bit more complicated, and they generally are, because anything that makes it more complicated for the landlord makes it a little bit easier for the tenant. Maybe the landlord will say, well, I won't file now, I'll wait until I see about the rental assistance. Once you get the case, it should have a bunch of stuff. If your landlord files an eviction, if you get served by the sheriff, it'll have a bunch of stuff attached to it, and talking to legal aid can help you sort out all of those attachments. In fact, there's a rule that the landlord has to attach any notice the landlord gave you and possibly a copy of the lease. And this is a change. It seems like it's COVID related because it happened in July 2020, but it was actually something that was being contemplated for a while, even before COVID. So, again, there'll be a lot of attachments, and calling legal aid will help you sort those out. You may have heard about the exception for tenants causing a health and safety risk. So again, any landlord can file a case right now. It doesn't have to be a health and safety risk, but there are still reasons why that's relevant. It could cause someone to be evicted more quickly. So again, the thing to remember about filing is that there are a lot of attachments, and if your landlord files an eviction, you will see what I'm talking about. All right, so then after the landlord gets it on file, gets it served by the sheriff, the landlord, him or herself, can't do the court papers. They have to either use the sheriff or a special process server. Doesn't really have to be a private detective, but you know, it has to be someone who comes out unrelated to the case who gives you the paperwork. Then there is a court date. All right, in the month of August, you can see how when I say this changes a lot, because right now there's a Supreme Court order that says that if the tenant has given the landlord a declaration, if the tenant is a covered person during August 2021, the courts cannot hold an eviction trial. So there can be some like a status or a clerk date or something, but not a trial. And that means that there can't be an eviction order entered. And this, the clarity of this makes the Illinois moratorium better than the CDC moratorium. A judge can hold a tenant in default. So the tenant needs to go to court. And I'm going to explain a little bit more about court in the COVID era. But if you know anyone with court papers, I know it's scary, but it's not something that you can put in your sock drawer and hope that it doesn't happen. By the time it gets to court papers, it's really serious. Okay, court is now being held by Zoom. If a tenant gets court papers, they're not really gonna go to the courthouse. They're gonna on their phone or on their computer, they're gonna connect to court by Zoom. I should say, let me go back a second. If you know somebody with court papers and they're figuring out what to do, and you know, like I now am like on Zoom constantly, probably some of you also, you work by Zoom, but there are people out there who aren't, and you know, may not have the technology. If they need to, they can go to the courthouse. They're not going to go into the courtroom like they would in pre-COVID times, but in each of the courthouses, there are spaces set aside and somebody from the judge's office that will help tenants log on to Zoom so that they can appear in court. You know, of course, anywhere with internet, a tenant might go to the library or something, although I understand, I mean, sometimes you have to wait for a little bit, and I understand that there can be a time limit on the computer at a library. So for people who need help accessing Zoom, they can go to the courthouse and someone will help hook them up to Zoom. When the tenant gets to court, and that, you know, it's going to be a whole bunch of faces and they're going to wait for their case to get called. And I know it's really intimidating, but all they need to say is, I want to talk to an ERP attorney. ERP is the Early Resolution Program funded by Cook County government. So it's countywide. You know, the magic of Zoom, I can be talking to a tenant in the Skokie courthouse and finish up with that tenant. And then my next tenant might be here in the city. So, you know, again, it is spending a little bit of time on Zoom, but the ERP attorney will talk to the tenant about the case, kind of help them assess the strengths and weaknesses of their case, try to help the tenant come to a conclusion what they'd like to do, if they'd like to make a settlement offer. There are also mediators who are available to help landlords and tenants talk through things. And the attorneys are usually pretty up to date on who has rental assistance money and can help kind of refer people for rental assistance. And I will say there are also ERP attorneys for landlords. You might think, oh, well, I must think that's a terrible thing because I want, you know, rights and services for tenants. It actually really helps settle cases because the landlord is conferring with an attorney as well. And then I get to talk to another attorney and that actually helps settle a case. The best thing about the ERP is that it automatically continues every case for 2 weeks. Back pre-COVID, it's very likely, if anyone here had, God forbid, been to eviction court before, that the judge tried to do a trial on the first day. Maybe you could get some kind of continuance, maybe 1 week to talk to an attorney, but it was really inconsistent. But here, if you say, I need to talk to an ERP attorney, it will automatically be transferred, or I'm sorry, it'll automatically be continued for 2 weeks. Okay. So I will explain, I was talking about the declaration. What if the landlord thinks the declaration is untrue? The landlord can file a motion challenging the declaration. And because it still has some meaning, here in August, I have 2 declaration hearings coming up this week. And they're almost always going to be on that 3rd paragraph about whether the tenant attempted to make partial payments if they could. And so again, if you can make a partial payment, I mean, if you can't, if you truly have 0 income, then you don't have to make a partial payment, but if you can at all, it's good to attempt. Okay, so right now, no eviction trials against covered persons in August. We actually are really hoping, maybe beyond hope, I don't know, but I couldn't do this job if I didn't have hope that either the governor or the Supreme Court will extend that into September. I will definitely try to help keep this information updated if that changes. But if, like, say the judge determines the tenant isn't a covered person, if that isn't alleged, if the judge enters an eviction order, then the landlord takes it to the sheriff. The CDC, Center for Disease Control Moratorium, prevents a sheriff from executing an eviction order. So during August, the Illinois moratorium protects tenants, even if the governor and the Illinois Supreme Court aren't able to take any more action, the CDC order will protect the execution of eviction orders in Illinois after September 1st. And that will be up to October 3rd. A bunch of attention to what the courts are saying about the CDC moratorium. But actually, I'm pleased to report in a really important case, the court let the order stand. So it's being challenged more and more. But for right now, the CDC order is going to protect against the sheriff coming out to execute the eviction order in September. Of course, these things aren't true for people who aren't covered persons, including that they didn't return a declaration. It's not true for the health and safety violations. The sheriff is executing eviction orders for people in those circumstances, or the people who had eviction orders entered against them prior to the pandemic. Now, this is actually what this little snip here is what it looks like if the sheriff writes a letter. If somebody gets that, they need to talk to legal aid right away. They can take a declaration into the sheriff's office. And I wouldn't mess around emailing it, even if it, I know it's easy for me to say to walk it into the Daily Center. I go downtown to our office, but to prevent an eviction, take a declaration to the sheriff's office. They're all the court system, the eviction system is in a very strange place, really unprecedented. And there can be any sort of reason why a sheriff letter might be coming out to a tenant, and somebody shouldn't say, oh no, I started paying my landlord again, I'm fine, you know, or I got all the rental assistance, you know, everything's fine with my landlord. If somebody gets a letter from the sheriff, they need to worry. They don't, it might be fine, but they can't just assume it's fine. They need to talk to somebody. And I will say the sheriff's office also has a department of, I think, Department of Supportive Services, what they call it, very friendly. Social work. When you get the letter from the sheriff, there is information on that. The sheriff's webpage is also very good with information about the eviction process. But at the very least, if someone gets a letter like this, they should call the sheriff's office. Okay. I think I brought that point home. And of course, each of these steps need to be followed. The landlord has to go to court. They have to get an actual order. It's not just filing the case, it's getting the order. And then they have to take it to the sheriff. You know, just once they get the order, that's not enough. They have to take it to the sheriff to execute it. Anything short of all of these steps that I'm talking about is an illegal eviction. And, you know, the Evanston City Police can help if a landlord is attempting to illegally evict someone. So I told you that I would let you know that there are resources out there. I know it's really scary, but there are more resources, more attention to eviction than in my whole 30-year legal aid career. If someone is, you know, like I said, you've gotten a sort of paperwork that you don't understand, and you can call or go to the website of Cook County Legal Aid. You will, you know, if you call during business hours, you'll talk to an attorney right away, and they can give you some more information. They can look up your case. You know, if you have court papers, they can look up the case and give you some more information, or you can call the LCBH intake line. And I know I dropped this or that about Chicago because I have mostly practiced in Chicago, but assume everything that I say about Chicago applies to our services for residents of Evanston as well. We're still not live answering the phone because we're working remotely, but please, people, leave a message. We call everyone back. We have the capacity to do intake in English and in Spanish live. And of course, we have access to interpreters for all other sorts of languages. All right, I'm going to stop for a little bit and see. I can't actually see if there are questions, but Megan is going to let us know. If there are questions about this part of it, then if you haven't typed in any questions yet, feel free to do that. We're going to then talk a little bit about sealing and we'll go back for more questions.
We don't actually have any questions as of right now. So yeah, quick reminder to anyone in the audience who does have questions, we'll have another round of Q&A at the end of the discussion. So feel free to submit those to the Q&A function. But for now, yeah, Javier, go ahead.
Yeah, hello everybody. I'm Javier with MTO. I just want to go over real quick about the eviction sealing law. So new law requires sealing every eviction acted between March 9th since last year up to March 31st of the next coming year, 2022. Next slide. So if your court case wasn't sealed from that time period, of course, could some slip through the cracks, right? You have to manually go in and seal it. The good thing is we have a tool available to us. It's called Rentervention. The link would be posted right there, but basically Rentervention can help you go back in and start this sealing process if your court case happens to be public record. So it's rentervention.com. Yep. The new law relaxes the standards for sealing eviction courts. The cutoff would be August 2022, next year, basically. So there are some criterias for what would qualify for this. One example is the case was dismissed with or without prejudice, is basically the court ruling that appears at the end of the case. There was, the other option is there was no material violation of the terms of the tenancy by the tenant. The parties to the eviction action agree to seal the court file. So basically landlord tenants agreeing to seal. And the interests of justice in sealing the court file outweigh the public interest in maintaining a public record. Yeah, so again, that was a quick overview of the sealing process. Again, the rentervention.com is a good tool to help you navigate this system. But yeah, I guess we're right now here for questions, me and Michelle.
Yeah, maybe we can just give folks a minute or so to submit questions through the Q&A function.
Yeah, and I could type in real quick the website Rentervention right here in the.
I will say, because as I pointed out, the law is changing a lot in this area. We try to keep information updated on our Facebook page. And I was thinking of that because also on our Facebook page, you'll see a little video that we made about how you can use Rentervention to create a seal motion. So if you just know, basically, all you need to know is your name, because you can look it up in the clerk of the court website. But if the more information you have about a past case, the better. You can just, you type it in. It's really, it's easier than buying something online, because you type in basically your contact information, and it makes a Word document that's a motion to seal. And then you can, because it's a Word document, you can add to it. It will email to you so that you can, if you need to make changes, or there are also instructions then on how to file it. And it is good throughout the state. We actually got a call already from someone, I think they were in Iowa, I can't remember, but someone in another state who has a case that was filed in Illinois, and they want to get that file sealed. And it doesn't matter where you are. It doesn't matter where you are in Illinois. You can file this seal motion, and especially now with court mostly being by Zoom. In a way, it's difficult for people who don't use Zoom, but if you're familiar with it, if you have a laptop, it does make it kind of easy.
Yeah, we got a question right here from Robert. How long does it take for the state to make a determination of whether or not a tenant gets relief?
Do you mean gets rental assistance? Oh, you can't actually answer that. I think that's what it means. I can tell you that the state has processed over $220 million in rental assistance. It has gone through all 70,000 applications that were submitted by the landlord. The ones that were like everything was perfect, they've mailed out those checks, and that's what they're doing, mailing a paper check. And then, so they did a pass through all of them. And this is really important. They could have just said, well, if it's not perfect, we're denying it. But they, and actually through some legislation passed by the General Assembly, said, well, there should be a cure process. If you accidentally uploaded the wrong, where you were supposed to upload your taxes, you uploaded, I don't know, some photos from a grade school party, then you should get a chance to go back and fix it. Anyone who has an application pending, especially with IDA, you can check the status. All you need to know is the application number and your zip code. You can go to that, check the status website, and it'll either say pending or approved or funded. Funded is the magic word because it means that the check is out the door. Also, in the you can get information about the IDA call center. If I haven't called it directly, some of my staff have, kind of to helping a client call, and they have had really positive experiences with the call center. I'm not sure, Javier, if
Yeah.
MCO was involved in the process. You might have some more,
Yeah, we
like
helped
direct on the.
Yeah, we help process some applications. If you applied through IHDA, they should have given you like an application ID number, and you could always check on their website for the status of like how far along it's processing. I can drop it in the chat, or I could do a quick screen share of how the website looks. If yeah, hold on, I'm trying to put it in the chat. Oh, sorry. So it would be this website right here, ilrpp.ihda.org/status. And if you have your application ID number, you just type it in, whatever zip code you're in, and it'll tell you how far along your application is in being processed. Do we have any other questions? Does that answer it, Robert?
Yeah, I hope that that's what you were asking, Robert.
Yeah.
But I think if we went off a different path, you can just type a question in again.
Okay, he said all good. Yeah. Here, I'll put the link right here in the chat. Okay, any other questions?
All right, well, since there seems to be no other questions, that will wrap us up for the evening. But as a reminder, this presentation and the slides will be added to the City of Evanston's website within the next week or so. But otherwise, thank you all for being here. And thank you, Michelle and Javier, for presenting this really crucial information. Appreciate it. And enjoy the rest of your evening.
Thank you. Always happy to do it.